So it should be pretty obvious, but I'm going to have to mute some of this because of my client's privacy. I want to keep them private, but I want to expose the judge and the opposing attorney for colluding in discrimination against my client. So this is going to be an excerpted judicial hearing, but you're going to hear the parts that are pertinent. You're going to hear my client saying that he does not have ADA access, and you're going to hear the judge's actions, and you're going to hear the judge act against him. So then you're going to hear the attorney, the opposing attorney, chime in and say some things that are untoward about my client's access as well. So let's get started.
Recording in progress.
There we go. Now we got Humpty Dumpty together. This is our Zoom hearing. I've initialized the recording device. Counsel, your appearance is for the record.
Your Honor, may it please Court, Patrick Blanchard, on behalf of...
Are you prepared to go forward with the hearing?
I do not have ADA access to the court. My attorney has not given me ADA access, and I am without representation.
Well, this isn't a criminal case. I can't appoint an attorney for you in this matter unless I'm going to consider putting you in jail for contempt of court. So
now this is the first time that the judge mentions contempt of court and jail. And this is just an intimidation tactic, especially after my client has invoked the ADA and asked for his ADA rights. And the fact that the judge is saying this isn't a criminal case and I can't appoint you an attorney, that has absolutely nothing to do with what my client just said. So the judge is just bullying the client already off the bat.
that's not a question of today.
I do not have ADA access to the court. My attorney has not given me ADA access, and I am without representation.
Just a moment, please. Hold on. I have something here.
What you're not going to see or hear in this video is that I had been in touch with the ADA coordinator, and the ADA coordinator said she was going to get in touch with the judge. So all this was happening about the same time, and the judge was unprepared to deal properly with the ADA.
Sorry for that interruption. They're unusual, but it was necessary, gentlemen. I would suggest that we have little choice other than to set this matter over on the Rule 170 question.
Now, I hate to throw my client's attorney, who he just fired, under the bus, but he brings out the ADA piece in open court, and this is a no-no. I mean, he's exposing his own client and the disability matters in open court, which gives the other attorney an open ground to jump on this and attack this.
For this hearing, and I assume hearings beyond, under the American Disabilities Act, and those haven't been met. And I'm not an expert on the ADA, but I have some understanding of it, that certain accommodations have to be made for individuals. And so I think under those circumstances, as is right, of the opinion that I'm not effectively representing him. I don't necessarily agree with that, but that is his right. I'm not sure that I can continue to serve as his advocate or provide legal counsel under these circumstances. It's the proverbial rock in the hard place.
I understand. I don't think we have much choice.
The judge is getting ready to say we're going to continue this, and then the opposing counsel kicks in. Here it is.
Your Honor, may I respond briefly?
Of course.
So for us to have to continue this again is an extreme prejudice to my client. The second thing is that we have no idea or understanding what ADA requirements requires, because if you're appearing by Zoom in your own home, which we believe that's where he is, how does he need an ADA accommodation?
What, Mr.
I do not have ADA access to the court.
Mr. We're going to get it for you. Well, I'd like everybody to come back here at 11:40. Can you come back today at 11:40?
Yes, Your Honor.
No, I am unavailable.
Okay. Why? Why are you unavailable?
First off, I do not have access to the court through ADA.
I'm still trying to figure this out.
All this is just a way to harm. It's an intentional act on Mr. part to try to harm her, and I think that's reprehensible.
All right, we're gonna take a 10-minute recess. I'll be right back.
Thank you.
You can bring it, you just walk that journal entry over here this afternoon, sign it.
I object.
Yeah, okay, you're already in contempt once, so don't go for twice. Don't interrupt me again.
So should I unmute and ask a question? Because it's just me and the judge now. Did you just threaten me with contempt asking for ADA accommodations? Judge? Meeting has been ended by host.
So I have sanitized this a bit so that my client or the opposing party are not exposed. But this is petitioner's second set of interrogatories and second request for production of documents to respondents. I just want to scroll on down here and show you what we got going on here on interrogatory number 3. Please provide the specific medical reason why you are entitled to an ADA accommodation to participate in a court hearing. This is the opposing counsel to my client who has a disability. The opposing counsel. As court hearings before Judge Journey are conducted by Zoom, stated specifically how that impairs you. As court hearings before Judge Journey are conducted by Zoom, stated specifically how that impairs your ability to attend the court hearings. I'm not even sure what this means. This is worded incorrectly, but this is another question as to the ADA and his impairment. And we go down here to request for production of documents. Like I said, I've deleted some of this because it goes to substantive matters. Produce copies of all medical records which support your claim that you need an ADA accommodation to attend court hearings. So this is Title II of the ADA. This is the final rule implementation. So we're going to go to, first part we're going to go to is 35.160. It's 28 CFR 35.160. This is B2, subparagraph B, subparagraph 2. This is the court's duty here, okay? In order to be effective, auxiliary aids and services must be provided in accessible formats in a timely manner and in such a way as to protect the privacy and independence of the individual with a disability. So the court has a duty. It says they must be provided in a way that protects the privacy and independence of the individual with a disability. So the judge, Judge Journey, in watching this go down, abandoned his duty and allowed the opposing counsel. Let's look at this now. 28 CFR 35.130, general prohibitions against discrimination. This is B5. Aid or perpetuate discrimination against a qualified individual with a disability by providing significant assistance to an agency, organization, or person that discriminates on the basis of disability in providing any aid, benefit, or service to the beneficiaries of the public entities program. So in this situation, what we saw was this. So we asked the court ADA coordinator for accommodation. The ADA coordinator passed it on to the judge. The judge, in addressing ADA matters, is just an administrator. It's not a judicial act. The judge engaged in the unlawful acts, that's 42 U.S. Code 12203B, and that's threatening, intimidating, coercing, and interfering with ADA rights. So he threatened contempt and proceeding even after saying he needed to continue the case. When my client objected, the judge threatened him with contempt and even mentioned contempt twice and jail once. The judge's failure to properly administrate and provide equal access allowed the opposing counsel to know and attack the disability matters of the disabled litigant, and the judge and the opposing counsel aided and perpetuated discrimination equally on the basis of disability. This has irreparably prejudiced my client's rights and ability to gain equal access in the courts. So yes, we're going to sue.